to all of our listeners, whether you are an employee or an employer, whether it is in a large sense or in a small sense, where you employ someone, you please remember the importance of governing the relationship with a written contract. Let's first start there. And then, according to the size of your company, make sure that you have an employee handbook. You will be surprised the amount of small and medium enterprises in Trinidad and Tobago with an absence of these things. And we're talking about these supermarkets, and these are the ones we're talking about medium size, hotel chains, etc. Without these things present, even if you are a minimum wage worker or you are employing minimum wage employees, you are still obligated to observe certain statutory requirements for employment. You know, Elena, I cannot help but stress the legal part of these things, because I feel as if, and this is the reason that we do all of these legal outreach, our culture is one that does not put a high priority on formalizing things, on utilizing law to govern things. And only when things go awry, you want the courts now to get involved and for miracles to happen. So we are trying to eliminate that today. So I think we're ready to go in to today's discussion, dismissal. All right? I would love to do a contract with you, but that's another time. So constructive dismissal. Elena, can you define this for me in its normal definition, and then let's break up the definition together.
All right. So, well, I wanted to give a very breakdown of constructive dismissal, and then I'll get into the formal definition. I also wanted to touch on a judgment, a recent judgment on constructive dismissal. So we do have a lot to cover. I'm very excited about this topic. Great. Simply because constructive dismissal happens a lot in the workplace, but because the employee has no idea that that is a constructive dismissal, they actually just walk away, and there is no recourse or no redress or anything like that. That happens a lot of times. So
and we are here to stop it from happening. So let's hear. How can someone recognize when constructive dismissal has in fact occurred?
All right. So constructive dismissal is this, where the employee is forced to resign his or her employment or job based on the employer's actions. That is, the employer would have breached that contract, gone to the root of that contract, or repudiated that contract. And
Lovely.
so
let's go that over again. Let's repeat because we want our listeners to stay with us. So let's go again. Constructive dismissal is
So
first of all, it must be forced.
Right. So the employee is forced to resign his or her job with or without notice based on the employer's actions. That is, the employer would have gone to the root of the contract, breached that contract, repudiated that contract.
I love it. I want to stick on those words. So forced, the employer forced, so is a forcing of a resignation done by the employer. Well, yeah, it is a forcing to resign or to leave or to exit, right? An ending of the contract, instigated by the employer, that they have gone to the root of the contract and repudiated, as the words that we would have used.
Yes, based on the actions of the employee feels that they have no choice but to resign.
Love that.
Right? So I have some book definitions because I wanted persons to actually see constructive dismissal as a very important element in employment law and in the employment relationship. Right? This is a very sensitive and very precise element in employment law. And that is why I really wanted to work with some documentation so that persons can have some sort of reference and can actually go on their own and do further reading, of course. So I would have taken some inserts from the Selwyn's Law of Employment, that would be the 17th edition. And under the heading of unfair dismissal, they would have also covered the issue of constructive dismissal.
Lovely.
Let me get
Before you continue, I just want to say, lovely, lovely. So you want to remind everyone who has joined us, remember that this is an interactive session. Feel free to speak with us. Feel free to respond in very, of course, respectful but meaningful ways in what we are saying so that we can get some feedback from you. Let us know if you are there. Good evening to all of you joining us. If you're now joining the discussion, we haven't really delved into it, but we've started on the issue of constructive dismissal. We have with us industrial relations specialist and industrial court advocate, Ms. Alina Alain, with us on our company discussing the characteristics of constructive dismissal. She has been able to give us a nice textbook definition of the same. And today, for the purpose of your edification, we're going into breaking down the definition, as well as giving supportive evidence by way of previous judgments where there's an actual and real-life application of the definition, and seeing ways in which you perhaps or someone you know may fit into what you are hearing. We have good evening, everyone. And now see everybody with us, man. Hi, I said Robert. Hi, Caroline. So Jennifer, good to see some of the regulars that we have here with us. Good evening to all of them. We appreciate you joining us. We already have someone saying it's the first time that they are hearing this term. You see?
Wow.
You see, it's the first time. So we're glad we're bringing something new to you, Carla, and we're going to delve right into it. So, Ms. Allen, you said that you're quoting from the 17th edition there.
Yes.
From one of your books.
All right. So, building on what I would have said before, they have also expounded further on the issue of constructive dismissal. And they stated that a constructive dismissal situation arises when the employer, without reasonable and proper cause, conducts himself in a manner calculated or likely to destroy or seriously damage the trust and confidence which must exist between the parties. A repudiatory breach, of contract, once it has happened, cannot be cured by the contract breaker, which is in this case the employer. Thus, even though the employer attempts to cure the breach before the employee resigns, there is no room for the argument that what the employer did was within the range of reasonable responses, for to do so would take away the innocent party, which would be the worker or the employee, option of accepting the breach and resigning in response to it. So, like I said, once that employer behaves in such a manner that it would have breached the trust and confidence of the employee, even though that employer would try to salvage the relationship, it doesn't actually stop the employee from claiming that constructive dismissal, because that trust and confidence would have already been lost.